Property Tribes TV, and joining me now on Skype, I'm delighted to welcome Steve Harriott, Chief Executive of TDS. So welcome along to Property Tribes, Steve.
Hiya, good to be here.
Very interesting times in the private rented sector. So much legislation, changes, controversy, negative headlines. And today we're really talking to you about the Deregulation Bill, because it's quite hard for landlords to keep up with everything, isn't it?
Absolutely. I think this legislation that's in the Deregulation Bill is designed to try to deal with some quite difficult cases that have been in the Court of Appeal in the last year or so around tenancy deposits, but it keeps changing. So even last week, the government introduced yet another amendment into the report stage of the bill. To deal with a judgment that came in at the end of last year. So it's a pretty fluid position that we're in at the moment.
And it's really Superstrike versus Rodriguez that has caused all this issues. Could you tell us kind of what the latest best practice is in terms of tenancy deposit protection?
Well, the Superstrike decision, if you remember, essentially said that if a fixed-term tenancy became a statutory periodic tenancy rolled into that new form, that effectively that was a new tenancy, and that required the deposit to be reprotected and also the prescribed information to be served. Now that was different, I think, to our understanding of legislation. I think before the Superstrike judgment, we had a view that if a deposit was taken before the 6th of April 2007, which was the trigger date of legislation, and then subsequently became a statutory periodic tenancy, then we and the government felt that that deposit didn't need to be protected. Now the Court of Appeal overturned that. And that was back in 2013, so it's taken nearly 2 years for appropriate amendments to be made to this legislation in the Deregulation Act. Is it worth me just talking through a little bit about what I think those changes are going to be, impact that they have? And it is relatively complicated, so apologies for that, and I'll try to deal with it as best I can. So for the Superstrike amendments, there are a couple of things I want to draw attention to. The first is, what do you do about deposits that were taken pre-6th of April 2007, which are still being held on a statutory periodic tenancy? So what the amendments are going to say is that if a landlord is holding a deposit which has not been protected, or the PI is served on a statutory periodic tenancy, then the landlord is going to be given 90 days, so 3 months, from the date of commencement of legislation to protect that deposit and to serve the PI. Now, we think legislation should probably get through by the end of March. That's our best guess at the moment. So once that legislation is passed, landlords will have 90 days in which to protect that deposit and serve PI. Now, that essentially addresses the Superstrike judgment, and there's that window of opportunity to get the thing sorted. There's a complication that if a landlord is being sued in the courts for non-protection of the deposit in these circumstances, or somebody's challenging a Section 21 notice because they're arguing the deposit wasn't properly protected, what the amendment goes on to say is that as long as you protect it the day before the court hearing, then you won't be found at fault.
Oh, okay.
That could be less than 90 days. So there is sort of get out of jail card free for people that may be facing challenges in the next 2 or 3 months. For deposits that are received on or after the 6th of April 2007, what do you do? Now, after the Superstrike judgment, we were telling people that if they had a properly protected deposit, and that deposit became a fixed-term tenancy or a statutory periodic tenancy thereafter, that you should probably serve the prescribed information again.
Just belts and braces, really.
Belt and braces approach. What the new legislation is saying is that if you had properly protected a deposit and served PI, and the tenancy became a new fixed-term tenancy or a new statutory periodic tenancy, then you don't have to reserve the prescribed information. Now that's a big improvement on our current confused position, where, as you say, for the belt and braces approach, we've been recommending landlords to reserve the PI. Now there's a couple of caveats on that. You have to have properly protected the deposit in the first place and serve the PI. And as long as the tenancy that you're creating, either through a new fixed term or a statutory periodic, is the same tenancy, so it has the same tenants, that's important, the landlords remain the same, and the property is the same, and the deposit remains in the same scheme, then you're covered. And that's a big improvement.
It is.
I think this nonsense of having to keep reserving the prescribed information will go away. And I think that once that's in, that will effectively protect landlords. And I know landlords have been concerned about, well, what happens if they haven't done this in the past? Can people go back and sue them in the courts for non-protection? And the government have dealt with that as well, because what they're now saying is, if the tenancy's ended, then effectively what the government is saying to landlords is that you're protected from prosecutions in the past. So they're making it clear that if somebody tries to go to court and argues that after a super strike judgment they should get a penalty, the courts are going to say, no, the tenancy's ended, so therefore you're assumed to have complied with legislation. So that's a super strike judgment. The recent amendment last week that came through was in relation to a Court of Appeal case in 2014 called the Charalambos case.
Yep.
And this related to the issue of Section 21 notice. Now, this actually applied to a situation where a tenancy had become a statutory periodic tenancy before the 6th of April 2007, and therefore did not need to be protected, nor does it now need to be protected. But what the Court of Appeal said was that in those circumstances, you still can't serve a Section 21 notice. So what in this particular case the court said was, because the tenancy deposit hadn't been protected, the landlord was prevented from serving a Section 21 notice. So how's government dealt with that? They've now amended the legislation to say explicitly that if a landlord wants to make use of a Section 21 notice in relation to a statutory periodic tenancy taken out before the 6th of April 2007, they can only serve that Section 21 if they have protected the deposit. So what that means for landlords is, if you're in that particular situation, I think it'll be quite unusual, you should nonetheless go and protect the deposit before you serve the Section 21 notice.
Fantastic. Well, thank you for those updates. And I'm guessing that if people need further information or they're unclear, they can visit the TDS website at tds.gb.com. But also you have events as well, don't you, Steve, for landlords?
We do. We have a range of events around the country. Details of those are on our website. I think at the moment you won't find this information on the website until the legislation is passed, because, as I say, it's being debated in the House of Lords. It will go back to the House of Commons. There could be some nuances and some further changes. So I think I'd advise your viewers to keep an eye out for our website. Once we have the final legislation in place, we'll publish the detailed guidance to landlords to take account of.
Fantastic. Well, thank you very much for joining us on Property Tribes TV, Steve. It's great to have your input, and also thank you to TDS for your ongoing support of our landlord learning. We really appreciate your input.
No problem.
Thank you.
Very much. Thank you.